I'm Nela Rush, and I work for CIS. I'm senior researcher. So I start with my boss, Mark Fricorian, who's the executive director of Center for Immigration Studies, and does not need introduction. And next to Mark is Jonathan Jakubowicz. That's the right pronunciation.
Jakubowicz, right?
Yeah, but it's my pronunciation. He's my friend, my dear friend, and kind of neighbor. And he's the founder and executive director of the Israeli Immigration Policy Center in Jerusalem. And last but not least, Rodrigo Ballester is head of the Center for European Studies at the Matthias Corvinus Collegium in Budapest. MCC is easier. So we heard a lot on asylum this morning, and I think everything was in point. I'm not going to repeat anything. I will let the panelists talk. I just want to say one thing. Think about it this way. If you want to come to a country, let's say you want to come to the United States, you apply for a visa, whether it's tourist or work or whatever. You wait, you do the papers, you do it. And if you're accepted, you're chosen, you have the privilege to come and stay in the United States. There's another option that we can see now more and more, and it's really being used by hundreds of thousands of people, is just to show up, mostly illegally, cross the border and then say, hey, I am persecuted, I want to claim asylum, and that's another entry ticket. Meanwhile, it has become, like Mark says, a stratagem to go to a rich country, or what I call an entry ticket to a country or a country shopping. So this kind of really annihilates every purpose of what the Refugee Convention was and what it was meant to be, meaning save lives, help people get out of a situation of real persecution. What we're going to talk about now is Mark is going, it's like the refugee system is broken. Everybody agrees on that, right? So Mark is going to say what needs to be done, and he's going to say, well, we just need to scrap the whole UN Refugee Convention, get out of it, and talk about sovereignty, taking back control, etc. Jonathan is also of the idea that the refugee system is broken, but he's going to show us a way to stay within the Refugee Convention and do it that way. And Rodrigo is we're going to cross the Atlantic, since we're in here and we are international, and he's going to show us how to take back control from Brussels, the EU, and the limiting rules there. Before I had the mic to Mark, there's a really important distinction between a refugee and asylum seeker. I'm talking about the United States. There's a program called the U.S. Refugee Resettlement Program that is official. The president sets a ceiling. It's numerically capped, limited. And we pick our own refugee. We decide who gets to come here as a refugee. It's a permanent condition, unlike what Christopher Lund was saying. Maybe we should do it more temporary, but we'll talk about that later maybe. And so you come here because we have chosen to give you refugee status and allow you into the United States on a permanent basis based on real persecution. The asylum seeker is a different thing. The asylum seeker is somebody who comes here, claims asylum, and then waits, as we saw, years and years and years to be granted asylum. And this is more of an imposed, it has become a right. We don't choose to allow these people here. They come here, and that's a difference. So it's supposed to be temporary when they come, but as we know, they come and stay years, and then nobody practically leaves. So that was a distinction I think important to make. So Mark, the floor is yours.
Thank you, Nela. The way I'd sum up what she said is that refugee resettlement is a sovereign act of a state. Asylum is the act of the migrant himself asserting a right to move and stay in your country, and it's a fundamental difference. And since the collapse of the Soviet Empire, asylum has become the main vehicle for illegal immigration to the developed world. As Nela pointed out, Yonatan and I basically will agree on what the specific kinds of changes we need, maybe not in every respect, but generally speaking. My contention where we differ is I think we need to scrap the whole framework of asylum, the current system that was set up. This was established in 1951 with the Convention relating to the status of refugees, and then was followed up with what's called the Protocol in 1967, which is what the United States signed. And so the question is, can reform be done? Even we agree on all what the reform should be. Is it more likely to happen if we stay within the current structure of the UN refugee rules, or do we need to scrap that system and do something new? Now, multilateral agreements like the Refugee Convention can work in theory, but they work best when they're dealing with practical matters between countries. For instance, the delivery of mail. The International Postal Union was started in 1874, and this is something that you need to have international agreements for. Air travel is another thing. Telephone service, consular relations. There's a treaty related to sort of setting out the rules of what the consular officials of one country, what kind of rights and privileges and responsibilities they have in other countries. But multilateral treaties that go beyond practical matters like that are at best virtue signaling. One of Senator Schmidt's predecessors, James Reed, senator from Missouri, in 1928 cast a vote to ratify the Kellogg-Briand Pact. And he called it an international kiss, that this is all this, it was like basically an air kiss, even though they didn't have that phrase 100 years ago. And what the Kellogg-Briand Pact did, actually it does, it's still in effect, is it outlawed war. So just in case you didn't know, war is illegal. Yeah, that's worked out great, especially since two of the signatories, Germany and Russia, a decade after signing it, invaded Poland and divided it up. So this is, these kind of multilateral treaties can be harmful, but in the best scenario, they're just virtue signaling. But multilateral agreements like the Refugee Convention are, in a sense, asymmetrical agreements. They bind democratic countries, I'll even say civilized countries, but do not affect the behavior of non-democratic countries at all, in any way. For instance, the 1951 Convention and the 67 Protocol, as well as things like the Convention Against Torture and the International Covenant on Civil and Political Rights, all have immigration-related consequences. Again, democratic nations see themselves as bound by these agreements and, maybe even more importantly, have domestic lobbies trying to enforce, either through political means, through lawsuits, enforce those provisions, whereas in non-democratic countries, there's no such restrictions. The 1951 Convention, the thing that set up the current system of refugees and asylum, 1951, and it was retrospective. In other words, it applied, in a sense, it was almost like the agreements about the mail and telephone service, because it was trying to clean up a specific problem. the dislocation in Europe caused by World War II and the Red Army takeover of Eastern Europe. It was informed in a way by the return of Soviet POWs, most of whom were either executed or sent to the Gulag. And so this is where this concept, it didn't come exclusively from this, the concept of, in French, non-refoulement, which would be non-refoulement in English, which doesn't mean anything. It's not a word. So you always italicize it and pronounce it in French, even in my pronunciation of French. But the point is sending people back to where they would suffer harm. But again, it was a very narrowly tailored agreement to deal with a specific problem. The real problem that we are now facing today, and this is the reason we have a asylum crisis worldwide, is the 1967 protocol, which is basically just an addendum that says the 1951 rules related to asylum and refugees apply not just to Europe, but to the whole world, and not just before 1951, but indefinitely into the future. And that's what we're facing. And the asymmetry of that agreement is clear from you look at the list of the signatories. I looked them up. Virtually all democratic countries are signatories to the convention and the protocol, except India. I'm not sure what's going on there, but I'm sure there's a story. But also such humanitarian paragons as Russia, China, Azerbaijan, Sudan, Iran, Zimbabwe, Afghanistan, Belarus. These countries have all signed this refugee protocol that we are, in Europe and the United States and Israel and Australia, are twisting ourselves into pretzels to comply with. And yet, does anybody think Belarus is worried about the rules of a refugee convention? It's preposterous. Likewise, in a sense, having these countries as part of a multilateral agreement related to human rights, because that's kind of the context within which it is kind of like having Iran on the UN Commission on the Status of Women, which it actually was, or having Cuba on the UN Human Rights Council. I mean, it's almost like something out of the Babylon Bee, but it's real. Likewise with the Torture Convention, the Convention Against Torture, which, how could you be against that? Who's for torture? Well, a lot of the countries who signed the Convention Against Torture, China, Russia, Azerbaijan, Syria, Sudan, Cuba, Pakistan. Again, and the reason I bring that up is because that has immigration consequences. We have bound ourselves not to deport people to places where they will be tortured. And the point of withdrawing from these treaties is not to enable the mass repatriation of people to someplace they're going to be killed or tortured. In other words, non-refoulement it's a concept that the publics in democratic countries, generally speaking, are going to ascribe to. In other words, you're not going to get a wide consensus to send people back to their deaths. But pulling out of these agreements is necessary because it restores national control over this decision-making, which illegal immigrants to send home, under what conditions. National laws could still be, in other words, if we got out of the conventions and changed our laws, they could still be subject to judicial obstruction. That's going to be the second panel, is the role of courts in preventing countries from exercising their sovereign rights. But there wouldn't be any outside authority, any skyhook, colloquially put, for advocates of or opponents of national sovereignty and immigration enforcement to refer to and to appeal to. And so, in my opinion, and this maybe is where I go even beyond where Chris Landau was, I think the only real solution is to abolish defensive asylum altogether. And in American law, I assume something similar exists elsewhere, but an affirmative asylum claim is somebody who is legally in the United States, as a student, for instance, and there's a coup back home, and his uncle was agriculture minister and has been executed, and so he can't go home. That's an affirmative asylum claim, and there's a lot of those, but that's a minority of the issue, and that's not the challenge, the sovereignty challenge. The sovereignty challenge is what we call defensive asylum claims, where a person is an illegal immigrant, either came across the border illegally, overstayed a legal visa, or maybe, and this happens pretty often, tore up his passport in the airplane, flushed it down the toilet, and shows up at JFK and says, you have to give me asylum. That needs to be abolished in principle. And the only way to do that and maintain the concept of non-refoulement, which again is broadly, it's something that I think democratic publics would adhere to, is to set up what I like to call remain in Mongolia. It always gets a laugh because, I don't mean any disrespect to people in Mongolia, but in English it's a funny name. This is different from remain in Mexico or from Italy's arrangement with Albania, which hasn't really gone into effect. And under those agreements, under remain in Mexico, the illegal immigrant still gets to apply for asylum in the United States. He just has to wait outside so that he doesn't just disappear within the United States. He doesn't get what the illegal immigrant is seeking, which is simple access to the United States, the ability to apply for asylum, not actually getting it. What I think we need to see, and this is what the asylum cooperative agreements were and are about, is you don't even get to apply for asylum. You are sent to somewhere, to another country where you can apply for asylum. One that isn't quite as appealing, but you won't be put to death. This is why Mongolia is a big place. I hear it's beautiful this time of year. It's got a lot of space. And there are plenty of countries in the world that, with the right financial incentives and other things, would be willing to be part of that kind of system, because once it became clear that uttering the word asylum on the Mexican border or when you're picked up by a boat in the Mediterranean isn't going to get you to your job in New York City or in Germany, very few people are going to attempt it. And so, in a sense, it's sort of not really, they wouldn't be making Mongolia or Botswana or Paraguay or wherever would not be taking on some enormous responsibility, because pretty quickly nobody's going to come, because why would you spend all the time and money and risk to go all the way through Mexico or cross the Sahara and get on a rickety boat in the Mediterranean if you're just going to end up in Mongolia? And so you could conceivably do all of this without withdrawing from the conventions. This is going to be Jonathan's point, and he may be right, I don't know. But my contention is it's necessary politically in order to get this process started, and it's necessary to deny oxygen to the domestic groups that oppose national sovereignty and will fight any measures to limit illegal immigration. Deny them oxygen in their efforts to prevent enforcement of immigration laws. So that's, did I go over?
You're
No, I
fine.
didn't actually. I have a minute and a half left, but that's fine. I'll give that to you, Jonathan.
Thanks, Mark. So, Jonathan, please feel free to agree to disagree with Mark.
Okay, thank you, Mark. Thank you, Nala. Thank you for all the other organizations, Numbers, FAIR, and CIS for organizing this amazing event. So, as Mark stated, I agree with the basic premise. I'll just add very shortly that I think most people agree that we have to uphold the concept of non-refoulement. But what most people don't understand, and I think Lando talked about it to a certain amount, is that the basis premise of the RSD process, the Refugee Status Determination process, that it's a feasible process that can be actually differ between real what we'd call bona fide refugees and migrant workers. That premise is fake. It's based mostly. There's a lot of people who are invested in that idea, lawyers, legal courts, humanitarian industrial complex. But in de facto, it's very, very difficult and it's very inefficient. So if we agree on that basic premise, the question is, do we have to leave the Geneva Convention or not? And what I would try to state is that we don't have to leave the Geneva Convention. I'll just go There's some important quotes I'll use here. But what I would claim is that not only don't we have to leave the Geneva Convention as it's worded and as the signatory countries planned, intended, allows us to do exactly what Mark offers. But what we do, we need to go what I call back to basics, going back to reading the Geneva Convention. And what most people don't know, and I see it in Israel, even judges who deal with asylum requests, people don't actually read the wording of the convention. So it's very important to understand that the convention is divided into 5 different levels of attachment, and every single clause in the convention opens with a level of legal status that the refugee has to hold in the country of asylum in order to receive those certain rights. Most people think that it's like a clear-cut distinction. If you're not a refugee, then you don't deserve rights, and if you are refugees, you deserve the whole set of legal rights, at least temporary residency and all social rights. But the fact of the matter is that the convention itself is divided into 5 different levels. The first would be subject to a state's jurisdiction. That would be the most important level, but the rights attributed are very minimal. Prohibiting discrimination based on race. Article 12 preserves personal status, and I grant access to the courts, which is a right that I think, I mean, of course, you'd want to limit it to a certain effect, but I think most basic human rights. The next level is physical presence, which gives a right to identification documents, and there's Article 31, which is a non-refoulement. It's not the non-refoulement, but it's not punishing people who entered directly from a country that they were in danger. By the way, I'll just on a side note, most people interpret that, the way most people interpret or understand that clause explains the problem of understanding the Refugee Convention. Because most people think that the convention says you're only a refugee if you come directly from a country you're in danger. But that's not what the Refugee Convention says. It says a refugee who has come directly from a country that he was in danger cannot be punished for illegal entry legally. No legal penalties. But it has nothing to do with the question if he's a refugee or not. And that also makes sense. I mean, if a person is really endangered in his country of origin, if he goes back, he'll be persecuted. But he passed 3 countries on the way, that danger has not, he's still in danger. So he still is a refugee. And people don't understand the concept. So the convention itself just talks about the effective rights that states have to give to refugees. So a person can be a refugee who came indirectly, and he can even be punished for illegally entering, even if he is a genuine refugee. The most important level of legal question for our issue and it all is what we call legal stay. And there's higher levels where you get the list of social security rights and all those things. That demands lawful staying and durable residence. The jurisprudence and people, the legal courts and what people talk about, we're just talking about lawful presence, which is the mid-tier. That's even before the vast majority of what we call social rights. And the main clause that the courts talk about is Article 32, which says that a refugee who's lawfully present cannot be sent to another country, Mongolia. We're not talking about Article 33, which says he can't be sent back to his home country, but Article 32 says that if he's lawfully present, he can't be sent to Mongolia. He can't be sent to another country. So the question is, what does lawfully present mean? So it's very interesting when we go back to the ad hoc committee on stateless and related problems. That was the drafting committee of the convention. So in January 1950, I'll just read the quote. They say the expression lawfully within their territory throughout this draft convention would exclude a refugee who, while lawfully admitted, had overstayed the period for which he was admitted, or was authored to stay. So according to the draft committee of the Refugee Convention, not only is a person who illegally enters not eligible for all these, for even Article 32, I'm not even talking about Social Security or housing or any of those benefits, but just to be protected from being able to be removed to Mongolia, not only is he unlawfully if he entered, but even if he entered lawfully and his visa for 3 months and he overstayed, or he did anything against the state revoked his visa, even in that situation, he would not enjoy the protection of Article 32. What's also important, and here there's nice quotes. Actually, the UK Supreme Court in 2012 had a very long verdict, UKSC 12. So Lord Hopes there says, and that's very relevant to the discourse. He says, I'll read it short. He says, with regard to interpreting the Refugee Convention, he said, we must interpret what the parties have agreed to. It has no warrants to give effect to what they might, in an ideal world, would have agreed. Another very important quote in my eyes, he said, we should bear in mind that there may be a profound gap between what commentators, however respected, and these would be academics or NGO members, would like the article to mean, and what it actually has been taken to mean in practice. And that's a very important quote from Lord Hope from the UK Supreme Court. And I would also add, if we're talking about the US, because we're in the US, that was how the courts in the US interpreted the Refugee Convention up until 1980 when it was legislated into law. But before that, the US was a signatory, but it wasn't in law. And so if you have the case Ming vs. Marx from 1974, so the court says the only rational interpretation that can be placed upon the term lawfully in their territory in Article 32 is one consistent with the definition of unlawfulness in Article 31 as involving status of being in a nation without authorization. Since a nation's immigration laws provide authorization, one unlawfully in the country is in a violation of these laws. This is a Second District Court of Appeals in the U.S., Federal Court of Appeals. So what the court is saying and what the Refugee Convention is actually saying is that states hold almost absolute power, even according to the Refugee Convention, meaning that states have the full prerogative to decide if a person is legally, illegally, and if he should stay in the country or not stay in the country. So if you want to promote stay in Mongolia policy, the Refugee Convention allows that in total. And I would argue, how much time do I have?
I don't know.
We have time?
She's the moderator.
Yeah.
Okay. Great. Okay. So I would say I would just add one additional fact about the Refugee Convention, is that as opposing to other conventions that have a treaty body or some tribunal which decides on the official interpretation of the treaty, the Refugee Convention has no such body. UNHCR tries to claim that it has authoritative responsibilities, but it does not. The Refugee Convention explicitly has no treaty body. So in addition to the wording of the text and what we saw that the draft committee and the way the courts have interpreted it, the UN Convention leaves the prerogative of interpreting the convention to every member state. Of course, it has to be, there are rules of interpretation according to the Vienna Convention, but at large, even what a refugee is or not, or how you interpret lawfully or unlawfully, all these are up to member states. And this was done on purpose because sovereignty, for sure in the 1950s, 51, was a very important issue for all member states signing the convention. So, why is this important? It's important because I believe that if we agree on the basic premise that, and I think the public agrees about it, like Mark stated, most people are kind. They do not want to send people back to any place that they'll be in real danger, but we have that real problem of how do we even process these requests and all the abuse. I think from a public point of view, leaving or scrapping the convention is a very harder position to explain and present to the public than staying within the guidelines of the convention, but just going back and using the original meaning and the original wording, and going back to what the courts in the U.S. have said up till 1980, which is not so far back. And I would also add, there is a manner of virtue signaling on all these humanitarian conventions, but I also I think there is an importance for some virtue signaling. I think there is the document is I see it as a human accomplishment. It is important that states, civilized states, agree on that concept. And I mean, it would be better if all states would do it, but I would add that some states that are not democratic do uphold. Like Iran actually has like one of the highest number of refugees in the world. They do it, but most countries do it like in refugee camps, like in Kenya, Uganda, which has one of the most liberal. The UNHCR calls it one of the most progressive refugee policies in the world. I think they're overstating it. But still, they give a piece of land to the person, but the Constitution says that a refugee and a refugee's descendant can never achieve citizenship in Uganda. Okay, and Uganda is progressive compared to Ethiopia, where most of the refugees live in camps. So I think that that virtue signaling works even for countries that are not liberal democracies, and I think that it's a very powerful achievement for humanity, but it has been abused and it's not working. So I would argue that all we have to do is go back and read the original text and read what the drafters said, and understand that we can achieve pretty much everything, and we both agree on the problems and what needs to be done. And I believe that staying in Mongolia is the future. I believe that will be the future. It's a matter of time. The more we can cooperate, the faster and more efficient it will be, and faster it'll happen. But that's the future of asylum. Anybody who deals with it in good faith understands that that would be the best option. And once it starts working, many countries will join. I think that's a good goal for INER. But I think that if there's no real reason to scrap the Refugee Convention, it would be much better to do the same policy but within that framework, which is both has value to itself and also would be easier to gain public support for such a move than to actually leave the convention. So that's where me and Mark differ a little, but we agree on the basics. So,
Okay.
finishing, if I have to sum it up, we have to go back to basics and read the Refugee Convention.
Thank you, Jonathan.
Thank you.
So let's go to Europe now with Rodrigo. You have an upcoming paper, and it's called Taking Back Control from Brussels, the renationalization of the EU migration and asylum policies. And what you're saying is that these policies have failed EU members, and they need to take back control and set a new legal and political paradigm grounded on democratic control and national security. So how will that take place, in your opinion?
Thank you very much, Naila, and also Yes, thank you very much. Thank you also, Mark, for the invitation. Very happy to be here. Also, thanks to my colleague and friend Victor. We drafted this paper together in Budapest. And the first thing I wanted to tell you is that everything I heard until now, so everything that Senator Schmidt said, that Mark said, sounds extremely familiar in Europe. Nothing of that was new, except that they have the impression that we are still the best or the worst in the world when it comes to that. No one faces such a migration systemic crisis for such a long time as we do. And so everything I heard about the NGOs, about the non-accompanied minors, about the abuse of asylum, about literally everything, if you want to know what is going on in Western Europe especially, you just take that and you multiply it at least by 10. And this is what you will get. And so today migration became a systemic threat, especially in Western Europe. And again, I don't want to go cliche by cliche, but those who used to travel to cities like Berlin, Amsterdam, Brussels, Ishten and Brussels, Paris, in many ways, you do not recognize them anymore. When we speak about also the criminality, which is the big elephant in the room, and the link between criminality and migration, I think that now again, we lost track. We lost track of all the crimes that happen on an everyday basis. The last one was 2 days ago in France, in Oléron. Oléron is a little city where, French people go on holidays, on the Atlantic coast. And again, there were stabbings, and again, a migrant was involved. Europe is facing this systemic crisis since much more time than you do, and worse, and also has a more difficult neighborhood. You are privileged, you are lucky. We are less lucky with our neighborhood. 14 kilometers away, we have the youngest continent on Earth, facing us, the oldest continent on Earth. And to the east is not so easy, to the northeast, to the southeast is not easy, and also to the northeast, we have a country like Belarus that openly uses migration as a weapon. And so, what I'm saying is that indeed, we need now a brand new paradigm on migration. What the tools and the conventions, international conventions we have now, is like basically regulating trade at the beginning of the Renaissance with the mentality of the Middle Age. So you are starting the capitalism and you are still in the mentality of the guilds and the brotherhoods. And this is what is happening. And this is why also, that's a little spoiler, but I do disagree, especially with you, Jonathan. I think that the Geneva Convention is very much part of the problem. And from a European point of view, also, our additional problem is that it's not the only layer that's causing problem, because first you have the international convention, so like the Geneva Convention. After that, we have the European Convention of Human Rights, which is also like a straight jacket and became really like a vital threat to Europe's survival, I would say. And then we have the European Union, case law and legislation, like hundreds of legislation. And then in some countries, like in France, for example, they also have their own judiciary problems. And for example, if you look at France and you look at the case law of what they call the Conseil Constitutionnel, which is somehow like the Supreme Court, basically there's nothing you can do to solve the problem of irregular migration. Nothing. They would not even allow, they say, a referendum. This is where they stand in France. And so indeed, I think that really, for Europe, the moment came to have a very radical approach. And since, what Mark called the Biden effect, this is what we had in Europe. I will call it the EU effect for 30 years. 30 years ago, basically, the member states decided to slowly give up their sovereignty in migration to the European Union. And 30 years after, the result, is a fiasco, is an absolute fiasco. By any means, you cannot say it wasn't successful. There are a couple of things I would keep. For example, like we have common databases, Schengen to a certain extent. This is something that the European citizens appreciate, that the fact that we can travel within the whole European Union, actually beyond, without showing a passport. But apart from that, it is not working. And again, we gave the competence also to an entity that has a bias on migration. The EU has a bias on migration and almost to an open border mentality. And also, we have to face that 27 member states have sometimes totally different interests and points of views. The situation of Spain, my original country, with a border, is not the same situation as Germany, who has no border with anyone, with any third countries, except, well, some see, but actually it's not relevant. But, for example, is the country that receives most asylum seekers in the EU. So it doesn't make sense to do it together, and indeed, I think now it's time to take back control, because we need a radical and very swift approach, and those are not the approaches that you can do, that you can coordinate with 27 people with totally different views, and then you can do quickly. And this is what we had in mind when we drafted this report that we really by coincidence, it was not a coordination, but we call it Taking Back Control from Brussels. But it seems that this is an idea that we are all sharing in the room, it seems, and on the both sides of the pond. And it's true that here we have 18 proposals that are openly disruptive. And the first 4 is how to legally disconnect the member states from all those layers, from the international one, the European Convention of Human Rights, and the EU. And then if member states have still problems at the national level, that is their problem. There's nothing we can do for them. But indeed, we have a concrete, legal techniques. For example, what we call a simplified reform of the EU treaties. I don't want to bother you with technicalities, but basically it means that if the 27 member states decide to give an opt-out to the others, we found a way to put it black and white on the treaties. And we have 2 countries in the European Union that enjoy this privilege, Ireland and Denmark. They are not bound by the EU legislation on migration, neither the case law, absolutely nothing. They are totally free to run their own migration policy. Ireland, to my taste, didn't do a very good job, but Denmark did. And Denmark today they had a huge structural problem, and they were able to take the bull by the horns and to change the course of the migration policy. And today, the socialist government of Denmark is actually the one running the most, the strictest migration policies in the European Union. And why? Because they are not subject to any European Union legislation or case law. And the question is, Italy wants the same, Hungary wants the same. And we don't get it why. Why? Now the time came indeed to request those opt-outs. And also, just to give you an example about the bias of the European Union, I just remind you that Hungary is basically the black sheep on migration and many other topics. But on migration, they saw it coming before than the others. One of the talents of Hungarians is that they have this instinct of, taking the right decisions a bit too early. And what happened is that since already a long time, they want the asylum seekers to claim asylum outside. And because of that, the European Union launched an infringement procedure against them. And since last year, for being right, and actually for doing what the EU is now accepting, more or less, Hungary is paying a daily fine of 1 million euro per day. 1 million euro per day. So 365 millions per year, just to defend their borders the way we are supposed to do it, which is indeed, to have a reasonable, very reasonable interpretation of the principe de non-refoulement. And coming back to the core of the question here in this panel is that, and why do I kindly but radically disagree, is that to start with, the non-refoulement is a schizophrenic principle for border guards. When a border guard is doing its job, his or her job, sorry, it means that it doesn't know if this job is illegal or not. Because at the end of the day, what does it mean to control the border is to do pushbacks. Is that somebody is trying to cross illegally a border, you push him back. The problem is that, but I might be an asylum, I might be a refugee, so I am an asylum seeker. And suddenly that means that it neutralizes, it totally thwarts the job of the border guards. Today, a lot of border guards in Europe, they don't know whether they're going to end up in jail or at least prosecuted just for doing their job. And those misunderstandings come from the Geneva Convention, but also for like decades of laxist interpretation of Geneva Convention. I agree with you on one point, is that if you read the convention, it looks tougher than it seems. But after 40 years of basically totally biased interpretation that leaked actually into the European Convention of Human Rights and leaked also into the European Union legislation, then the core of this problem is the Geneva Convention. And again, from a European point of view, for those who believe, and I'm definitely one of them, that migration became an existential threat, we don't have time now to change until the judges correctly interpret the text that has been the source of the problems. And at least what we advocate in this report is to get out of the Geneva Convention, at least for a while, to send a signal, 3-4 years, and then let's see. We also ask in this report some of the member states that if they don't get the legal reforms that will allow them to take back control, we just tell them to take it. If after 2 years the other member states do not agree to have an opt-out for them, just do it. And this is a debate that is actually not only for, it goes beyond conservative circles. The other day, the Polish Prime Minister, Mr. Donald Tusk, who is basically the EU's best friend, and somebody who is absolutely not a conservative, is rather good at persecuting conservatives in this country, openly said that if there is no way to reform the European Convention of Human Rights, be it, we will just leave. He just said it. And that means that, you know, what used to be a dogma, what used to be blasphemous, is no longer the case. And those are good news because we need to have a very frank debate on that. And this is the point, the very point of this report. Again, we will be labeled as very bad things for publishing it. But it's true that here we want to be disruptive. We want to basically take so that the nations, at least those who still want, have the means to take back control. We also propose other things, for example, on the funding of NGOs. That was mentioned as well in the introductory remarks. I mean, why some people called NGOs, which actually, I mean, it's even a prostituted name, why those people are just allowed to circumvent the law and to help others to circumvent the law? I just don't get it. Also, is it possible to get EU funding to build fences? Fences work. They do work, except that until now, the member states had to pay them from their own pocket. Can we deprive the European Union from any competence on family reunification? You know that me, as a Spaniard living in Hungary, now, just because of thanks to European law, I could bring even a mother-in-law from Qatar if I had one. I mean, why is the mother-in-law of a you know, like a third country national be allowed to stay in Europe, for example? By the way, no one needs a mother-in-law at home.
Okay, let's go there.
But basically,
okay. In 1 minute.
1 more minute. Schengen, just last example is Schengen. Schengen, again, Europeans are attached to it. It's true. But why we don't limit Schengen to Europeans? Why, for example, an Algerian national that is legally residing in France suddenly has the same right as me when he goes to Hungary to spend for a weekend? If Hungary wants to impose a visa to this Algerian national to visit Budapest, we say, why not? And it's true that here the asylum has been like the highway of abuse, of illegal migration, and it's true that that's why I disagree again, and we think that in order to take back control and to recover the sovereignty, the first step indeed is to at least suspend all those international conventions that basically are a straitjacket on member states' national sovereignty. Thank you.
2 against you. Okay. Quick question mark. Yeah, a quick question mark to you, because you talk about putting out from the UN Convention and stuff. Can you tell us in practice how this works, if, let's say, President Trump wants to, and also perhaps give us some policies that any president can do to either close the border, make asylum harder or not, based on what happened, especially with detention, non-detention, or just no asylum claims, quickly.
As far as the treaties go, that's a contested issue because the Senate has to ratify a treaty. But the practice has been the president has sole authority to get out of a treaty. All treaties have escape clauses usually, you have to write someone, announce to somebody that you're pulling out, and then 6 months or 12 months later. And the Refugee Convention, you have to write, I believe the Secretary General of the UN has to be notified, and there's a 12-month period, and then you're out of it. So, and we've done that with the anti-ballistic missile treaty. The president has unilaterally pulled out of it. Also, some others. There would be, the Democrats in the Senate would probably object, but that's happened before and it hasn't stuck. So the president can do this on his own if he chose to do so.
And remember that Trump did not sign into the UN Convention's compacts on refugees and migration. So presidents do have power sometimes to do things and
to not do things.
And to not do things. Jonathan, quickly, very quickly, because that's very interesting. When you talk about the refugee status determination, specifically the social group, tell us a little bit about that, because social group has been widened and widened so much that it's been kind of used for a lot.
Right. So one of the other issues of the Refugee Convention is just endless widening of that clause. And today, social group can be a woman, but climate refugees. Okay, it's open to endless interpretation. So that is another problem. So there's two issues: what level of rights and what is a refugee. But I think that if we limit the level of rights that we give to refugees, then we can circumvent the discussion or the trying to differ factually, because when you do an RSD process, there is some kind, you agree on what a refugee is and what is not, and you're trying to determine if that person who has no identity, who has no papers, who has no nothing, it's a totally inefficient process. So you have the problem of technically identifying if he is a refugee. And the other question is, what is a refugee? Is domestic violence a reason for refuge? Is war? What's persecution? Those are other bigger questions, and those questions I don't believe are simple to solve. So I believe that all you have to do is just, if we're talking, let's say, about the U.S., instead of leaving the convention, all you have to do is change the immigration law and say a refugee will receive the right to stay until he's sent to Mongolia. That's it, and that's all you have to change. The reason in most of the world that they don't apply it is because the Refugee Convention was adopted into the legal documents. So at any rate, any country would have to change its legal law, and it could achieve the exact same goal without leaving the convention. And the difficulties that you will have publicly, politically, will be the same both ways. So there is no magic solution to it. But I believe that the easier way and the more practical way would be to just change the level of rights that the refugees achieve through legislation, and then you don't have to deal with those questions, which are almost impossible to decide upon.
Did the two men convince you just a little bit or no?
Just very quickly, I mean, I think most of Europe's problems are with the European Convention of Human Rights, much less the Geneva Convention. Most of the verdicts are the European Convention. Second thing, you see even countries that left the EU, like the UK, the crisis got even worse. It's for a certain extent, they were able to, they stopped having migrants come from Eastern Europe, which would be more educated, more similar culturally, and they're having a more difficult time of blocking migrants from third world countries. So at the end of the day, you have all the problems that are real problems, political, cultural, all those things won't just disappear. And they won't just go away. And the courts, and this we know from Israel, just one last sentence, the courts are not usually very receptive. I mean, courts have their life of their own. They like a court, if he wants to, if they want to promote a certain agenda, they'll do it with the convention, without the convention, and that's another issue. So, question is, it's a hard problem, but I still think that the Geneva Convention, not the European, the Convention European Rights, That is less of a problem, and I still think that it would be a more feasible goal to stay within the framework and change legislation.
So, Rodrigo, do you think this is doable, and how are you going to push for that? Which countries do you think you can bring towards you, or with this political change in Europe? Is this just utopia?
No. It's much better than that. But just to agree, it's true. You're right. The European Convention of Human Rights and even the EU, as such, is more is actually more problematic than the Geneva Convention. Geneva Convention is much better drafted. You are right. It's not so laxist. It's just the way it is interpreted. But you are right that in our approach, the Geneva Convention will pay maybe a higher price, because it's the origin, of the problem that was created by other courts. I just give you a very quick example. Recently, the European Court of Justice, so the EU Court of Justice, said that just by being an Afghan woman, per se, you are eligible for subsidiary protection. So I don't know how many women you have in Afghanistan, but I'm sure that some of them are the wives of little Taliban. And they just have the right to come.
Nicola wrote about that.
Yeah, and so sorry, but that cannot go on. We have a graph here in the report. I brought you some copies. We'll publish it next week officially, but just one graph here. Those are the red line. The blue line are the accepted asylum requests. The negative asylum request, the red line, and the gray line are the asylum requests. I think it speaks by itself. And to answer your question, there is a political will to move on. Hungary will do it. Hungary already requested this opt-out. Poland as well. Think about the Netherlands. And think about also, for example, Sweden is a country that also is very, very threatened by. I'm sure that most of Central and Eastern Europe will also take this opportunity. So no. You have, for example, 9 countries.
We will be looking into that.
Yeah, 9 countries already wrote a letter to say that they don't want to deal with the European Convention of Human Rights anymore. 9 countries taking this bold step.
Yeah.
It's significant.
Well, thank you, everybody. I just want to wrap up here and say most refugees stay in their own region, and we have a chance to help them better where they are, and perhaps not allow them or not give them any incentive to make the trip to go to developed countries. And I think proximity help can be also, and the pushing for a return, pushing for resolve of conflict could be also one of the solutions to any refugee crisis. Thank you, and look forward to the rest of the day.